the matter of Jersey Choice Limited against His Majesty's Treasury.
This appeal concerns liability to pay value-added tax on low-value goods, which were sold and dispatched by mail order from the Channel Islands to customers in the United Kingdom at the time when the United Kingdom was a member of the European Union. The appellant, Jersey Choice Limited, is a Jersey-registered company that grows horticultural products in Jersey, which it mainly exports directly to consumers in the United Kingdom in small packets by way of mail order. Prior to a change in the law in 2012, these goods were exempt from value-added tax when imported to the UK. This was because they were subject to a form of VAT relief known as Low Value Consignment Relief, which meant that no VAT was payable on goods imported into the UK with a value of £15 or less. However, in 2012, the United Kingdom passed legislation which removed this relief for mail order imports from the Channel Islands. This was intended to combat a practice known as round-tripping, which involved exporting goods from the United Kingdom to the Channel Islands, only to then re-import the goods into the United Kingdom with no VAT. It is not suggested that Jersey Choice took part in that practice. Jersey Choice brought a claim against the Treasury. It claims that the withdrawal of VAT relief for low-value imports from Jersey was a serious breach of EU law, which was contrary to the Treaty on the Functioning of the European Union and general principles of EU law, including the principles of equal treatment and proportionality. Jersey Choice seeks damages against the United Kingdom government, known as a claim for Frankovich damages, to compensate it for the loss it has suffered from what it claims is a serious breach of EU law by the United Kingdom government. Jersey Choice's particulars of claim were struck out by the High Court for disclosing no reasonable grounds for bringing the claim. That decision was upheld by the Court of Appeal. Jersey Choice now appeals to the Supreme Court. Before describing the outcome of this appeal, I should say a few words by way of context. This case involves considerable analysis of European Union law. While it is now over 4 years since the United Kingdom left the European Union and 3 years since the end of the transition period, Jersey Choice's claim against the Treasury was brought in 2018 when the United Kingdom was still a member state, and it seeks damages for alleged breaches of EU law by the United Kingdom from as far back as 2012. When this case was before the Court of Appeal, that court dealt with the applicable law following Brexit in detail and concluded that Jersey Choice was able to proceed with its claim in view of the provisions of the EU Withdrawal Act 2018. Both parties agree with the Court of Appeal's analysis. The Supreme Court has proceeded on this basis without having heard any argument on this matter and should not be taken as approving this analysis. More generally, however, it's important to note that the law applied in this judgment is no longer the current law within the United Kingdom. The Supreme Court unanimously dismisses Jersey Choice's appeal. The High Court and the Court of Appeal were right to conclude that Jersey Choice's particulars of claim disclosed no reasonable grounds for the claim. A joint judgment is delivered by Lady Rose and myself, with whom Lord Briggs, Lord Leggett and Lord Richards agree. Jersey Choice's primary ground for its claim is that when the United Kingdom imposed VAT on low-value goods imported from the Channel Islands, this amounted to a charge having effect equivalent to a customs duty, which is prohibited by the EU treaty provisions on the free movement of goods. When the United Kingdom was a member state, the Channel Islands formed part of the EU customs union, and so it would be unlawful for the United Kingdom to impose customs duties on goods imported from Jersey or charges having equivalent effect. However, the Treasury argue that the VAT raised on goods imported from the Channel Islands was not a charge having effect equivalent to a customs duty because, instead, it amounted to internal taxation. Internal taxation falls to be assessed under the rules for the EU fiscal regime, not the EU customs regime. The lower courts found in favour of the Treasury on this point. We agree. For a measure to be characterized as equivalent to a customs duty, it must satisfy two tests. First, it must be shown that the charge affects only imported products, as opposed to internal taxation, which affects imported products and domestic products alike. Secondly, the measure must not be part of a general system of internal dues applicable systematically to categories of products according to objective criteria applied without regard to the origin of the products. In the present case, the charge of VAT on imports from the Channel Islands fails both tests. As regards the first test, the mere fact that a charge is made because goods cross a border cannot of itself make it equivalent to a customs duty. Otherwise, all charges to VAT on importation would be equivalent to a customs duty. The charge arises because importation counts as a relevant transaction for the purposes of the VAT system. Corresponding products supplied within the UK are subject to VAT in the same way. The charge also fails the second test because it is part of a general system of internal dues applicable systematically to categories of products according to objective criteria applied without regard to origin. VAT is a recognized turnover tax applied across the European Union. The provisions allowing member states to exempt low-value goods from VAT are found in the Exemptions Directive, which is undoubtedly a tax law. Jersey Choice also claims that the United Kingdom breached general principles of EU law by removing VAT relief for low-value imports from the Channel Islands, but leaving it in place for low-value imports from other territories. In particular, it compares the Channel Islands with other territories which fall within the EU customs union, but are not subject to the EU rules on VAT governed by the VAT Directive. Jersey Choice gives the example of the Åland Islands, an autonomous region of Finland, which was still able to benefit from VAT relief for low-value imports into the United Kingdom after the relief was removed for the Channel Islands. We reject this argument. While the general principle of equal treatment applies in the field of taxation, that principle has no application to imports from third countries. The key question is whether Jersey should be treated as a third country or as a member state in the context of the VAT Directive. We hold that Jersey was a third country for the purposes of the VAT Directive. The Directive made clear that imports from the Channel Islands were to be treated as being from a third territory, notwithstanding that the Channel Islands formed part of the customs union. This reflects the selective application of EU law to the Channel Islands, as agreed in the Treaty of Accession of 1972, when the United Kingdom first joined what was then called the European Economic Community. For these reasons, Jersey Choice's appeal is dismissed.